Good morning, everybody, and welcome to the House Judiciary Committee. I'm sorry for the delay this morning. I always like to start promptly, but that's not always possible. So would our clerk please call the roll?
Representative Banta.
Present.
Representative Blanton. Representative Bratcher.
Here.
Representative Bray. Representative Burke.
Here.
Representative Dietz.
Here.
Representative Down. Representative Flannery.
Here.
Representative Herron.
Here.
Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox.
Here.
Representative Mosier.
I'm here.
Representative Nemus. Representative Petrie.
Here.
Representative Rawlings.
Here.
Representative Sharp.
Present.
Representative Stevenson. Representative Wilson.
Here.
Vice Chair Decker.
Here.
Chair Elliott.
I'm here. So we do have a quorum, and we're duly constituted to conduct business. Two bills on the agenda today, and we will first hear House Bill 451, Representative Nick Wilson. And if you would introduce yourselves and for the record, and then you can proceed.
Thank you, Mr. Chairman. I'm Representative Nick Wilson, 82nd District. I'll allow my guest to introduce himself.
I'm John Lally. I'm an attorney in Louisville, Kentucky.
We're here today for House Bill 451. It would create a new section to allow for a will to refer to a separate written statement or list in order to dispose of items of tangible personal property not otherwise specifically bequeathed. It's common practice for a will to refer to a separate writing so that a testator may devise of his or her personal property without specifically listing each piece of personal property in the will. Personal property, thinking of things like quilts or collectibles, or for me and my sons, probably baseball cards. I was surprised to learn that Kentucky hasn't codified this practice. I believe it's 33 other states that have. My bill draft before us today is based off Virginia's law. The goal is to be more flexible, to update gifts without needing to update the will, which is a more stringent process, and it should be. Wills should be hard to update.
There's a motion. Is there a second?
Second.
There's
Thank
a
you.
second.
I'll allow my guest to maybe say a few words if you have anything, or
Yeah,
if
please.
you would just like
Please proceed.
Again, my name's John Lally. I practice in Louisville, Kentucky. I was admitted to the bar in 1992, and I've been practicing in the area of wills and estate planning for 32 years. I do handle very small estates, just mom and pops, and they come into my office a lot of times and they ask, I don't really know right now while I'm making my will who I want this property to go to. I might want to change it down the road. Sometimes they have problems in the family with arguments, drug problems, alcohol problems, or whatever, and they decide they want their property to go to another child. And when I first started practicing, we were typing wills, and we would do all this by codicil. It's easy to change wills now, but it's still it's almost as time consuming as writing a new will. You have to have them in. You have to have two witnesses and a notary to execute the new will. There's consultation involved and those kinds of things. And this bill would make it easier for a person to change their mind. And it doesn't involve, the the family farm or the house going to somebody or another. So the stakes are really low on this, but it's something that's really important to my clients. It's something that they do ask about. Right now, I do have kind of a way to do that. I tell them that if they write a list in their own handwriting, sign it, and date it, it could be treated in court as a holographic codicil, but still, I think that causes a little bit of problem because you have to have witnesses come in after they've passed on to prove that that's their handwriting and that was their will or their codicil. So I think that this would make it more convenient and more cost effective for my clients. It wouldn't really impact my business at all because I feel kind of ashamed to even charge them for making a simple change of their will, and I think that it would be a good for the people of the Commonwealth.
So if there's no questions, I'd ask.
There are some questions.
thank you.
Representative Burke.
Thank you, Mr. Chair, and thank you, Rep. Wilson, for bringing this bill. I think this is really useful proposal. I have a question that I brought to your attention earlier. I really love the idea of being able to provide a typewritten list of tangible personal property either before or after creation of the will. What I'm curious about is if there would be any benefit or usefulness in allowing or actually requiring the testator to at least sign the typewritten document, not requiring a formal signing ceremony, not notarized, but just to affix a signature to that document so that in essence it would appear to be most certainly from the testator as opposed to from someone else who's seeking to gain from the personal property.
I think that's a great question. Like I said, we modeled this off Virginia. I don't know why they don't have it in there. I don't know if there's a reason or not a reason. Do you have an opinion, Mr. Lally, on requiring a signature on the list?
It would certainly add to the to be able to verify that the testator signed, that this was the testator's will.
I'd be happy to put that in a floor amendment to shore up the bill.
Yeah, that would be great, and I appreciate your willingness to hear my question on that. And I again want to thank you. I think this is a really useful bill.
And if I could, I think that there is a danger that they won't do that, but because we all use our word processors and they do like to type it out and make it all look neat and everything. But again, I think that the risk of it failing is low because we're just talking about tangible personal property. So I think that that having a requirement of a signature on it would be beneficial.
May I, Speaker?
Yes, go ahead.
Thank you, Chair. Just thinking through the proposed or possible floor amendment, you could even make it where a signature creates a rebuttable presumption that it's accurate as opposed to, a certainty, so that if the signature is not affixed, it is still valid, something along those lines.
I think it's a great idea.
Thank you.
So I was just notified by my staff, Josh Nacy, that line 9 does indicate that it is signed by the testator. Is that in your proposal? So I think that might go to what Representative Burke was asking. So the handwritten document would have to be signed. Is that right?
Yes.
Yes.
So I
yes,
think that,
Mr. Chairman.
I think that's in there. So good deal. It was great idea. It was so good they adopted it.
So Virginia does have it.
So is there any other discussion? If not, Representative Petrie.
Thank you, Mr. Chairman. And if I may, just some small questions. I just want to
Go ahead.
clarify some
Yes,
language. Good on the concept and practice in Todd County is much the same as you described in Louisville. Usually low dollar figure, have a list to the side. The only difference I heard in my practice and yours is that I would counsel that is a preferential list, not enforceable by court, just to err on the safe side. I think this makes a good statement in the right direction. Just looking through the bill, it looks like referring to a separate written statement on the word written, handwritten and typed, or just typed, or handwritten only.
I think that I would say typed because that's the way people are doing it now. I would prefer handwritten just for authenticity, but and you tell people that, and they look at you like they're crazy because they want to type it up and then laminate it and 3-hole punch it and put it in a binder. Yeah. And you look at it and say that's no good.
Right. If y'all would be willing to talk about that, discuss that possibly as a floor amendment, just to clarify exactly what we mean by the word written. And then statement or list to be given effect to the extent that it does not, and it doesn't conflict with whatever the testament might be. So if there's one item, I've got 16 items in my list, and there's one item that refers to a certain set of dishes, and that certain set of dishes is also dealt with in the will proper, but it's to two different people, does that knock out the entire list, or are you just excluding the one item on the list that conflicts with the will? Can't tell from the wording of the document whether it's the list has to be entirely not in conflict, or you just exclude those items that are in conflict and keep with the remainder. So I'd want to clarify that if possible. And then I asked Representative Burke's question on the signature, which is in the bill on line 9. Thoughts about considering putting a date as well on the document. So in practice, I would tell them to sign it, date it, and I would even tell them to initial each line because especially if it's typed out, someone else could add type over the top of that document. Handwriting is a little more hard to falsify. But if you've got a date on it, signature and or initials, just to make sure it is what the person is intending, that's all. Things worth considering for floor amendments, not asking for a commitment. Does that make sense?
Yes, it makes sense, especially signing and dating it.
Yes.
It's supposed to be easier than just redoing the will.
Yes.
So
usually which hopefully brings me to my last point. We want to be careful. One of the reasons I'm trying to be careful about this is this. Usually we refer to dishes and coffee makers and the furniture and the quilt and things like that. But this is tangible personal property, which could include very expensive farm equipment, could include very expensive equipment, mechanic and otherwise, could be automobiles, could be a lot of things that could be high dollar figures. So although we may be thinking right now about dishes and coffee pots and quilts, this will likely be utilized, and I would be one of the people that would do it. This would be utilized to distribute some very expensive items and circumvent the will and the protections around that when you get to more expensive items that are being distributed by inheritance. So I just want to clarify that. I think we ought to look especially on the requirements to make sure it's valid, and we've got to keep an eye on how expensive are these items we can pass with a off-will list.
Yeah, that makes me think of jewelry as well at that point. So
Yes, very good. Thanks, Mr. Chairman.
Thank you. If there's no other discussion, I think we've had a motion and a second. So would you call the roll, Mr. Clerk?
Representative Banta.
Yes.
Representative Blanton. Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan. Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus. Representative Petrie.
Mr. Chairman, yes, with a caveat, I'd like to continue conversations for possible floor amendments regarding the issues we raised. Thank you. Yes.
Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
If I may, I'm going to
Yes.
pass because I think we have these procedures to have wills be validated for a reason, and I want to make sure that whatever we do, whatever codicil we do, whatever writing we do, has some safeguards. And so I like the gentleman's suggestions, and I want to see that they are put in an amendment, so I'll pass for.
Representative Wilson.
Yes.
Chair Elliott.
Aye. So with 16 yes votes, no votes, and no pass votes, one pass vote, House Bill 320 is, well, no, it's not 320, I'm sorry. House Bill 451 is favorably passed with favorable expression. Congratulations. The next item is House Bill 320, an act relating to statutes of limitation. And I'll turn the meeting over to my vice chairman, and she will conduct the proceedings from here.
Chairman Elliott, will you introduce those at the table with you and proceed?
Thank you, Madam Chairman. Good morning. I'm Daniel Elliott. I'm the state representative for the 54th District, and I have some guests with me, and I'll allow them to introduce themselves.
Good morning, Madam Chair. I'm Kate Shank, Senior Vice President of Public Affairs for the Kentucky Chamber.
Madam Chair, I'm Robert Hudson. I'm an attorney with Frost Brown Todd.
Thank you. Oh, there's a committee sub, PHS3. Is there a motion to adopt the committee? Second?
I second the motion.
All in favor, please indicate by saying aye.
Aye.
Opposed? The committee sub is adopted. Are there any? Well, you may proceed.
Right. Thank you very much. And good morning again. House Bill 320 is an act relating to statutes of limitation. It would amend KRS 337.385 to establish a statute of limitations of 3 years for wage and hour violations and 3 years in the case of willful violations. And it would further amend KRS 413.125 to establish a statute of limitations of 3 years for a violation of KRS Chapter 344 relating to civil rights and for actions against an employer for wrongful discharge in violation of public policy. So the purpose behind this bill is to align Kentucky's statute of limitations for employment-related claims with federal law and competitor states. Under current Kentucky law, employment-related claims such as alleged wage and hour violations or alleged employment discrimination fall under the state's 5-year catch-all statute of limitations. And Kentucky's 5-year statute of limitations for employment-related claims far exceeds federal standards and the laws of competitor states. And this excessive time period makes Kentucky an extreme outlier for employers when it comes to potential employment-related litigation and allows stale claims to be filed when defense witnesses are harder to track down, memories have faded. In addition, it has the effect of imposing more long-term and unique record-keeping mandates on employers creating jobs in Kentucky. The other change in the committee sub is a change to our long-arm statute, which is an amendment that was brought to me by Representative Nemes. And so under the U.S. Constitution, the Due Process Clause establishes the minimum contacts that an individual in our state who has been harmed or wronged by a person or a company in another state establishes the process in which litigation can be brought. A court case in Kentucky, unfortunately, or fortunately or unfortunately, indicated that the way that our law was written, that a plaintiff could not establish minimum contacts through the through the Constitution, and so we feel that a statutory change, which has been adopted by I think about 30 states, that this bill would do, would allow our citizens to more easily establish minimum contacts with either a corporation or an individual in another state, as long as they've conducted business in the state. And that language is in the substitute. So I'll yield to my guests for any comments that they may have.
Thank you. And Madam Chairman, members of the committee, appreciate the opportunity to speak in support of this legislation. The Chamber is always looking at where our laws deviate from competitor states, surrounding states, and looking for opportunities to improve our competitiveness. But also with this particular legislation, we think it's important that these cases be brought sooner. We think it's beneficial to both parties because of the reasons that Chair Elliott laid out, and the amount of time and what can happen during that time period, the memories that can fade, and the details related to that. And so we bring this legislation because we know it's important from a competitiveness standpoint, as well as for parties involved in these cases. We appreciate Representative Elliott's leadership on this issue. This comes to us from a lot of our members that have representatives that deal with these particular cases. I do have my colleague Rob Hudson here, who can speak more in more detail about the effect of the statute of limitation and provide you with a little bit more information around the specifics and the challenges that he has faced. So I'll turn it over to him for some brief comments as well.
Thank you. I've been practicing labor and employment law, primarily representing employers, for more than 30 years in Kentucky. We find ourselves here on Small Business Day. I primarily represent small employers. It is an honor to play even the smallest role to help them realize their American dreams. They, however, are most frequently the subject of these types of lawsuits. This bill's a good first step towards easing unfair litigation burdens for them, making Kentucky more competitive with surrounding states in this area of the law, for 4 reasons. Lengthy periods of limitations are particularly problematic in employment cases, particularly for smaller employers. First, in employment litigation, the relevant behaviors involved can stretch back well beyond the 5-year period of limitations. You don't necessarily decide to terminate an employee in one day. It's a process that builds often over a period of time. With our current 5-year period of limitations, we're talking about looking at events that commenced 8 years, 9 years ago. Respectfully, it's tough for our legal system to require an employer to reconstruct and essentially prove what happened that long ago. Second, employment cases involve uniquely complex and nuanced decisions. The employee who strikes someone physically in the workplace that's witnessed by 2 individuals doesn't file a lawsuit. Interestingly, most frequently the types of lawsuits I receive are from managers who've been fired for poor leadership, that the company is actually attempting to help the workforce as a whole by removing that individual. But a removal based on leadership is nuanced, it's complex. So when we're looking back 5 years, 6 years, 7 years, 8 years, at those types of decisions and having to essentially prove them up in court to prevail, we believe that's unjust to employers. Third, employment decisions often involve multiple managers, multiple co-employees, thousands of emails and text messages. I cannot compute or fully share with you, and I'm probably a little embarrassed by it, how many hours I've spent in my legal career trying to read and understand text messages written by 20-somethings in their own language. And that is the key evidence in cases these days. But what if you had to defend that based on an 8-year-old text message? Number one, would the text message even be available? Are the emails available? Is the individual available? These are most frequently not simple cases. They involve intent, proving someone's intent. The employer thinks it had a righteous intent. The employee, former employee, thinks that there was an illegal intent. That type of case makes it particularly unjust, again, to subject the employer to that sort of litigation with a lengthy period of limitations. Fourth, the stakes are uniquely high in Kentucky for employers with employment litigation, particularly for small employers. This makes the fairness of the process even more important because, unlike federal law, Kentucky imposes personal liability on the owners of small businesses for several types of claims, along with uncapped damages for humiliation and embarrassment. Insurance is not always the answer for a smaller employer. Their limits will typically be much lower and insufficient to cover the claim. If the small employer loses that case, even if they did the right thing and the trier of fact simply disagrees, it means the small employer paying their own attorney's fees, paying the other side's attorney's fees, paying uncapped damages for humiliation and embarrassment in most cases, and other economic damages. Reducing the period of limitations is a strong step towards making the process more fair. I'd like to close by thanking the sponsor of the bill, Chair Elliott. Some of these issues are ones that you'd never really know about unless you're involved in this sort of litigation. Well, there are a lot of Kentucky small employers who know about these issues. With my law practice being in northern Kentucky, I work with clients who have matters in Kentucky. I'm also licensed in Ohio, where I do a lot of work. I have colleagues who support clients in Tennessee and Indiana. These are our major border states where there's a lot of competition across borders. When I talk with clients, they ask me the question, why are things so different in Kentucky compared to federal
Motion on the bill
law?
is amended by the sub.
The General Assembly has done great work on improving Kentucky's competitiveness relative to other businesses. I just can't stress enough how important this work is to us. Thank you.
Thank you, Chair. I want to tip my hat to the sponsor on this, particularly as it relates to the clarification of the long-arm statute. Seems like it was a really necessary fix, and so I'm grateful to see that. I have a question about Section 1, Part 2 on line 9, where it says an action for violation of KRS Chapter 344. So this bill proposes a 3-year statute of limitations, but in Chapter 344, Section 650, relating to housing discrimination, there is a 2-year statute of limitations, which it looks like we'd be expanding. Is that the intent of the bill, or is that something that is unintended?
Are you looking at the sub? I think that we had restricted it to employment-related matters, I thought was what the sub had done. So,
well, line 9 says an action for violation of KRS Chapter 344, which includes housing discrimination, which I don't think is the target here.
That wasn't my intent. It was intended only at employment-related claims.
Okay.
So,
to that end, I would hope to see a floor amendment or something along those lines that clarifies that this is not impacting the housing discrimination portion of
Sure.
Chapter 344. And if I may, one other question.
Although it would give them some additional time, I guess, right? So I don't know that it would be detrimental to someone who had experienced or thought they'd experienced housing discrimination. But go ahead.
You may ask one more question.
Thank you. Did the Cabinet of Labor and Employment express any concerns about this bill?
They have not. I haven't reached out to them, but I haven't heard anything at this point.
Okay. Thank you.
Thank you. Representative Stevenson?
My parents own a small business, so I'm big small business girl. And my question is this. When we, in the Air Force, I practiced employment law, and we documented. We knew when we had a bad leader, and we documented so that when we had to fire them, we had documentation. And you seem to think that's too much of a burden in this case. Like, I'm trying to understand why small businesses can't document and preserve the rule of law by proving they should fire somebody.
Is that directed to me?
Well, yes.
I apologize. I wish that small businesses across the board could document things better. It's simply a matter of, I mean, you imagine you've got that dream and you have a product and you're trying to stay afloat and you're trying to grow the business. Sometimes documentation is not the highest priority for those folks.
Okay. And my second question, if I may, Madam Chair.
You may proceed.
Is who is against this bill? What do you have any organizations like Plaintiff Bar or people that represent the workers that are against it?
I'm not aware of anybody who's against it because I think it strikes a balance between giving the employee the right and a sufficient amount of time in a 3-year period to file litigation if they think they've been if they haven't been paid properly or they've been terminated wrongfully. So going from 5 years to 3 years is a sufficient amount of time and fair to the employee. And it's also, to your question about the record keeping that a small business may have to keep, they're only going to have to do that now for 3 years. So to my knowledge, nobody is opposed to it, which is sometimes hard to do up here, isn't it, to get a bill that nobody's opposed to. So
thank you.
Seeing no other questions, there's been a motion and a second. Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Bray, Representative Burke,
I'm going to pass, and I'd like to explain my vote.
Please, go ahead.
While I'm completely on board with the long arm provisions, I do need some additional clarity as it relates to how Chapter 344 is going to be affected, because there are so many different subsections of Chapter 344. I don't want to impact the ability of people to make claims if there's discrimination in education, for example. So I just need further clarity there, and hopefully I can be a yes on the floor.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery,
I'd like to vote yes and explain my vote. Some of the comments I've heard today indicate that shortening the statute of limitations actually, I guess, would decrease lawsuits. I don't know if I entirely believe that. I think sometimes when we have a shorter statute of limitations period, it actually causes more lawsuits to be filed. So as we kind of discuss these matters, regardless of what type of laws we're dealing with, I think we need to keep that in mind. Thank you.
Representative Herron,
pass.
Representative Kulkarni,
I'm a pass for today. I understand the intent of the bill. Briefly explain, Chairman. I apologize. I do think the inclusion of Chapter 344 in its entirety, since that wasn't the intent of the sponsor, needs to be clarified and looked at. further. So I'm going to pass for today with the understanding that that's going to be clarified before it gets to the floor. Thank you.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosher,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson.
If I could explain my vote.
Yes, please.
Okay. I am a pass for today because, like you said, it's rarely that we have somebody that's not in opposition. And I want to hear what the plaintiff's attorneys have to say and how this will impact them. Because small businesses and big businesses have more wherewithal to fend against this than the everyday worker. So I'll pass until we get some clarity about that.
Representative Wilson,
Yes.
Chair Elliott.
Aye.
Thank you. Appreciate it. Good to meet you. Likewise.
With 15 yes votes, 0 no votes, and 4 pass votes, House Bill 320, as amended by the committee sub, is passed and will be reported with favorable expression that the same should pass.
Madam Chairwoman, there's a title amendment, motion on the title amendment.
Yes. Motion second, all in favor? Opposed? It's adopted. Thank you. Motion to adjourn, and it's passed. Adjournment.
Mr. Chairman, I need to
Yes.
register a vote for House Bill 450, a yes vote for House Bill
Yes.
451.
We'll recognize you for that purpose.
I register.
Representative Nemus,
I do so. I vote yes on House Bill 451. Thank you.
I vote. Own.
Yeah. Mr. Chairman, I'd like to record my presence as well as a yes vote on House Bill 451.
Thank you, sir.
Thanks.